go ahead and get started. Well, thank you everyone for joining me today on the second webinar in our four-part series. In case you weren't on our last one, my name is Bryan Meek. I'm a partner attorney at Brennan, Manna and Diamond and the co-chair of our labor and employment division. Today, we're going to talk about two issues that are really, plaguing employers right now. And honestly, they're the two issues that are leading to the most liability for employers that we're now currently seeing, and that is employee misclassification as well as discrimination in the workplace. So I know we only have this webinar slotted for 30 minutes. Obviously, we want to be here for the questions that you may have. Feel free to put those in the Q&A box throughout the presentation, and my colleague Sarah will read those out as we go along. But we can certainly stay after and answer any questions you have. But given that short time, I want to go ahead and just kind of jump right into things. So make sure we're on the slides here. So today we're going to talk about, as I previewed, employee misclassification, really focusing on two aspects, and that's classifying employees as exempt versus non-exempt, as well as when a individual should be classified as an employee versus a contractor. Second, we're going to talk about discrimination in the workplace and changes to the protected classes that have occurred over the last year and where we're really seeing discrimination enforcement. As to the second bullet point on this slide now, you'll notice that I have a quick discussion on a joint partnership between the EEOC and the Department of Labor's Wage and Hour Division. That's kind of why these two topics have really been coupled together. And that's because these two agencies have officially entered into a memorandum of understanding where they will be jointly investigating and alerting the other agency to issues. So what I mean by this, and we'll discuss this more in a moment, is if the EEOC is doing an investigation into discrimination and they notice wage and hour issues, they're also going to be turning those wage and hour issues over to the Department of Labor and vice versa. So this is one of these times where these agencies really didn't communicate a whole lot together before this memorandum of understanding, but we're now expecting more investigations to come about as a result of this memorandum. But we'll get to that in a moment. Let's start with employee misclassification. And again, this primarily comes from the Fair Labor Standards Act. Most states have their own version of this act. Largely, they mirror its requirements, but we're going to focus today primarily on the federal statute. So if you have state-specific questions, don't hesitate to reach out to me after the presentation. We can discuss those. But the Fair Labor Standards Act is the federal statute that establishes minimum wage requirements as well as overtime pay, along with hour tracking and hour record keeping. Why is this statute important? Well, it's the statute that determines, one, who is exempt versus non-exempt for your employees, and two, it really leads to the guidance as to who is a contractor versus an employee. Sometimes we hear the phrase 1099 employee thrown around. That's not really a thing. You're either a 1099 contractor or you're a W-2 employee. There's really no such thing as a 1099 contractor. That can just lead to liability issues. But again, we'll get to that in a moment. So the FLSA basic requirements, as contained on the screen now, the FLSA entitles non-exempt workers to at least minimum wage per hour. Currently at the federal level, that's $7.25 an hour, obviously very low. Most states have higher minimum wages, and we have to follow those higher minimum wages. It also establishes that employees must be paid at least time and a half for overtime. So any hours worked above and beyond those 40 hours must be paid at their hourly rate times time and a half. This FLSA, as I had indicated, applies to exempt versus non-exempt, establishes who those are. Only non-exempt employees must be paid at least this minimum wage and at least this overtime. Your exempt employees, aren't compensated for overtime, but we just can't go around calling every employee exempt, right? That would defeat the purpose of the statute. So this statute also establishes what are the requirements for an employee to be called exempt and therefore not have to be paid overtime. Application to contractors, as on one of the bullet points on this slide, the FLSA does not apply to your contractors. To your validly classified contractors who are issued a 1099, the FLSA is not going to apply to them. You don't have to ensure that they're paid at least minimum wage. You don't have to pay them overtime. You don't have to, ensure that, your record keeping how many hours they work. You can pay them a flat fee as well for the services they perform. But there's a caveat. We just can't call all of our workers contractors, right? There's certain requirements as to who can become a contractor, and largely it's very limited. We're seeing it now more and more kind of come up again, where a lot of employers are starting to try to call workers contractors. Sometimes it's because the worker has requested them. We know oftentimes physicians like to be considered contractors rather than employees for tax issues. But by and large, most of your workers are not going to be valid contractors. So we'll get into that in a moment, but just kind of a precursor there. So takeaway here, the FLSA applies to your employees as to who's exempt, who's non-exempt. Also mandates that non-exempt employees be paid overtime and minimum wage. So who is considered exempt? I think, to start this, we're going to say exempt employees are those that, are on these classifications on these screens, and each one of these classifications has their own requirements. We're going to talk about a few of them here today. But by and large, anyone who doesn't fit within this screen is going to be non-exempt, or anyone who doesn't fit the requirements of any of these exemptions on the screen is going to be non-exempt. Now, one of the overarching requirements for many of these exempt positions that are on the screen now is that they're paid on a salary basis. That means they must earn a salary, at least a certain amount per week. I think it's $658 right now per week. And that amount cannot go up or down based on how many hours they work. And it can't go up or down based on quality of work. So for your exempt employees, they're paid on this salary basis, right? You're non-exempt, 99% of the time are paid hourly. You can technically pay a non-exempt employee a salary, but that's a topic for another day and really complicates things. But by and large, your non-exempts are paid hourly, your exempts are paid a salary that does not go up or down, and that's a very important component. But I have a note on the screen here, and it's important to reiterate that if you do have exempt employees, currently there is a proposed rule that's going through, and we do expect the final rule to be published in April of 2024 that is going to increase the minimum salary per week to at least $1,059. That's obviously a significant increase from the current $658. So what that means is, in order for those employees, if they're not making $1,059 per week come April, when the final rule goes into place, you're going to have two options. Either you have to move them down into a non-exempt status, begin tracking their hours, paying them overtime, or you're going to have to increase their salary to ensure they meet that exemption threshold. But approximately that's going to result in it, if you're making the bare minimum exemption requirement, a $20,000 salary increase for those exempt employees. So let's start with, obviously, the main exemption classifications we're going to talk about today are the 1, 2, and 3, the executive employees, your administrative employees, and your professional employees. Let's get started quickly with the executive employee exemptions. Again, as you'll see, the first requirement, be paid a salary basis. I'm sorry, it was $684 per week. I misspoke. The second requirement is the employee's primary duty is the managing of the enterprise or managing and customarily recognized departments or subdivisions of an enterprise. And what they mean by enterprise is the company, the business. These most basic are your CEOs, COOs, CFOs, very high-ranking directors, very high-ranking managers. Those are those that are typically going to fall within the executive exemption. These are the employees that regularly direct the work of at least 2 or more full-time employees. CEO might direct work to 2 directors that fall underneath them. So these are those, kind of setting those policies, setting the work requirements at the top, and then letting things trickle down from there. Again, very high-ranking employees. Finally, these employees must have the authority to hire and fire employees, and discipline, things like that. These are the ones running the business. Those are the ones that are going to fall into the executive exemption. More commonly, we often see the administrative exemption being used. Again, there's a requirement to pay them at least a salary of $684 per week. The other requirements that you have to meet are the primary duty for the administrative exemption is the performance of office or non-manual work that's directly related to the management of the business or the operations of the business. So common examples of this are the folks that work in HR, the folks that work in accounting, marketing, etc. They're the ones that are performing this office work that directly relates to the management of the business. The third requirement here is that these employees have to be able to exercise independent discretion and judgment. And what do I mean by that? So if you have someone in HR and their sole purpose is to sit there and just input hours worked to spit out the pay for employees into a computer system, they're not really exercising independent discretion and judgment, right? The person, however, in HR who's responsible for interviewing candidates, onboarding candidates and developing those onboarding policies and ensuring all that paperwork is complete and rectifying issues with onboarding. The folks in HR who are responsible for firing, they're the ones exercising independent discretion and judgment. So that's one where employees often get tripped up, is they say, hey, I have someone in marketing, who is all they do is post stuff to the internet, right? They take the articles that someone else wrote, they just post them to the internet. That's probably not going to fall into exemption, right? Because they're not really exercising independent discretion or judgment. There's already this process in place of how things get posted to the internet, and they make those postings. So it's one of those times where if you're looking to the administrative exemption and you feel like, yeah, it kind of falls on the line, definitely reach out to an attorney. We can evaluate that position for you and give our recommendation as to the exemption status. The last exemption status we're really going to cover here is the professional employee exemption. These are ones that, again, have to be paid on a salary basis of at least $684 per week. And they're the ones who are performing work that requires advanced knowledge, and 99% of the time as a result of an advanced degree, at least a bachelor's in the area where they're performing the work. And oftentimes we're talking about employees with higher levels of education. And the advanced knowledge that they're using to perform the work must be in a field of science or learning. And the knowledge must be customarily acquired by a prolonged course of specialized instruction. So most commonly for this, doctors and lawyers are obviously going to meet this. Interestingly, we'll come back to that in a moment. But so not only your doctors and lawyers, but your nurses, technically RNs, can fall into the professional employee exemption, assuming they have at least a bachelor's in nursing. Now, your PRNs or LPNs, not likely to fall into that, into this professional employee exemption, especially for your LPNs, because they don't have that advanced degree, that high level bachelor's in nursing. It's typically a lesser degree. Often areas where we see employees get tripped up here, especially given that so many of my clients are healthcare, is going to be with, as I said, LPNs, but then also nurse practitioners. And let me explain why. So technically, a nurse practitioner is easily going to meet the professional employee exemption when it comes to the duties. They have a degree higher than a bachelor's, and it's in a field of study. They're serving as nurse practitioners. They're treating patients. Where we find the issue, though, is technically for this employee exemption, there's a caveat that says those practicing in the field of medicine or law do not need to be paid the salary requirement of $684 per week. So they may pay them per patient, or they may pay them a percentage of the revenue that nurse practitioner collects. Well, that exception to the salary basis requirement is only for truly MDs and DOs. It doesn't fall down below into nurse practitioners as well. So again, that cutoff for that exemption. So a lot of our healthcare clients kind of get into trouble there because they're paying these nurse practitioners on a per patient basis or a percentage basis rather than the $684 per week. So that's just to demonstrate, there's a lot of complexities that go within these exemption requirements. So it's always great to, speak with an attorney or, some sort of trusted HR advisor to ensure that all the requirements are being met. Quickly, I just want to cover employees versus...
Bryan, I'm sorry.
Yep.
You do have a question.
Sure.
Katrina's asking, what about your LISW or social worker?
So that is a great question, actually. And honestly, I've litigated 2 cases involving social workers. It's not, unfortunately, a question I can answer on this presentation today, because there's going to be more follow-up and questions that I'm going to have regarding what duties they're performing, what degrees they have, what's their level of licensing. So if you would like to reach out to me after the presentation, we can certainly schedule a call to go through those specifics. But unfortunately, just with that information provided, I can't necessarily specify today. So moving into contractors versus employees, as I said, the FLSA doesn't apply to contractors, just to employees. But again, it's important that we are correctly classifying our workers as contractors versus, when they're validly contractors and not employees. And the reason being, if you are improperly classifying a worker as a contractor and they're not meeting the requirements of being a contractor, and most do not, you're going to run into penalties under the FLSA because they're technically employees. Number one. Number two, the IRS can come down on you for tax issues for failure to collect employment taxes. So it is imperative, if the biggest takeaway from this presentation today is, if you are classifying your workers as contractors, definitely be speaking with your attorney to clarify they are actually contractors. Again, there's no such thing as a 1099 employee. If you're calling someone a 1099 employee, they're probably not validly going to be a contractor. We just can't start issuing, form 1099s and call them contractors. There is certain criteria that still must be met. The IRS has their own rule of who's an employee versus a contractor. The Department of Labor has their own rule. We're going to talk about the Department of Labor's rule today, but by and large, they're the same. If you're going to meet the Department of Labor, you're going to meet the IRS. So let's start with, some of the factors, and it's not, you don't have to necessarily meet all these factors. It's a scale that's weighted case by case, but the factors that most courts and the Department of Labor look at are on the screen now. The first being, the extent to which the services rendered by the worker are an integral part of the business. So the example I often like to use is, if you're hiring, let's say you're a medical office, and you're hiring someone to come in and fix the toilet, such as a plumber. That worker to fix that toilet is a contractor. The office isn't in the business of plumbing, right? The medical office. But if you're hiring, say, an RN who just wants to come in part-time and work 5 to 10 hours per week, you're in the business of treating medicine. That RN is providing services, for what your business actually is performing. That RN is going to be an employee. Now, they'll be a part-time employee, right? Only working 5 to 10 hours per week, but they're still going to be an employee, even if they want to be a 1099. Number two, the relationship's permanency. So again, plumber comes in, it's a one-off job. Maybe you call him back 2 weeks later if it breaks again. Sure. But permanency is something that's looked at. That RN that's coming in to work 5 to 10 hours per week, that's expected to, last theoretically, forever, right? Until that RN decides to part ways, or you just decide to part ways with them. So again, looking at that permanency. Number three, the amount of the worker's investment in the facilities and the equipment. For a contractor is investing in their own facilities, in their own equipment. Your plumber has their own truck. They have their own tools that they're bringing to your job site to fix the toilet. The medical office, on the other hand, when that RN comes in to work part-time, 5 to 10 hours a week, are they bringing their own, stethoscopes? Are they bringing their own, stitches and other items and materials necessary for the treatment of patients? Are they actually paying rent at the facility to treat patients? Are they investing in any way into the facility itself? 99% of the time, the answer to that question is no. So again, falls in line with that RN being an employee. Number four, the nature and degree of control of the employer. When that plumber comes in, you might say, hey, I need you here at Monday at 8 a.m. to fix the toilet, but you're not telling them how to fix the toilet, right? When that RN comes in for 5 to 10 hours per week, you're going to say, hey, here's how we intake a patient. Here's how we evaluate a patient. And then here's how you're going to fill out the chart and bill the patient. Now, that nurse might still be, operating within the scope of their license and training, but, they are, still relying on the degree and control of the employer in the performance of those duties. The employer is doing the credentialing, things like that. There's that level of control over that RN. Number five, the workers' opportunities for profit and losses. This one's a bit more complex, but going back to the plumber example, the efficiency and effectiveness at which they work can lead to more pay for them, right? So your plumber comes in and they fix your toilet within 30 minutes. They can now get on to the next, next customer. Or if it takes them 4 hours, they're going slower than most others, they're now suffering a profit loss. So that's kind of what that's looking like. To what extent does their efficiency and effectiveness really translate to them earning more profit for their business? Number 6, the amount of initiative and judgment or foresight in the market competition required for the success of the worker. That's super complex, but again, that just kind of goes down to, do they need to run a business in order to be successful? And that actually translates into 7, do they actually have a business organization? Those are the factors. Again, definitely speak with your attorney if you have people classified as contractors that after hearing these factors, you're now, pausing and saying, hey, I'm not so sure anymore.
We have another question on that slide.
Sure.
So the question is about number 4. If the employer is responsible for a certain amount of training, that can factor in as the worker being an employee instead of an independent contractor?
That's correct. Yep. Yeah. If an employer is providing training on how to perform services for that company, probably most likely going to be an employee. Now, I might be able to hear an argument that could change that, but I'm starting to think employee in that case. Just some other, immaterial factors that people often try to cite to, but aren't necessarily indicative. Number 2 I want to talk about here is the absence of a formal agreement. Oftentimes we hear clients say, well, hey, if I just write an agreement that says they're a contractor, right? No, that's immaterial under the law. It doesn't matter whether you have a written contract in place that says they're a contractor, or an agreement that says they get a 1099. That's immaterial. It doesn't matter what you contract for. We're still looking at the requirements under the law. So I want to now touch base on here just a couple more minutes. This wage and hour and EEOC memorandum of understanding. As I kind of teased in the beginning, on September 13th of this year, 2023, the Department of Labor, through its wage and hour division and its EEOC division, entered into a memorandum of understanding that says that these 2 agencies will begin information sharing about their investigations. Again, so if Department of Labor is coming in to investigate you for wage and hour issues, and they discover discrimination concerns, they're going to pass those discrimination concerns onto the EEOC for them to also perform an investigation. Traditionally, that has not occurred, right? If you have a wage and hour investigation, you oftentimes aren't going to get a discrimination investigation out of it. Now you might, or vice versa. So number 2, coordinated investigations and enforcement. As I just said, they're going to coordinate also on those investigations. So if wage and hour needs to go back to your facility, they might be saying, well, hey, EEOC, why don't you come along with us? And number 3, they're going to be training each other's staff to spot discrimination issues. So wage and hour, hey, here's how you spot a discrimination issue, maybe in pay or anything else. Hey, EEOC, here's how you're going to spot a wage and hour issue, and then report it back to us so we can conduct an investigation. What this is really telling lawyers is that the Department of Labor is really ramping up their investigations into employers to ensure that things like the FLSA and the discrimination requirements are being followed. Again, these are the areas that lead to the most litigation and most liability for employers. So we want to make sure that these things are covered. There's been a couple changes to the protected classes in discrimination over the last couple of years. As most of you recall, most of us are in at-will employment states, meaning you can fire an employee anytime you want for any reason, right? They come in 5 minutes late, you can fire them. But what you can't do is fire them, for an illegal reason. So any reason at all, as long as it's not illegal, right? So what's an illegal reason? By and large, it's going to be discrimination issues. Could also be, retaliation issues. But by and large, discrimination. So we've expanded what those protected classes are. Number 1, the Supreme Court has expanded the definition of sex under Title VII and Title IX to include sexual orientation, gender identity, and gender expression. So again, really protecting the LGBTQ+ community with that protected class. Number 2 is going to be the recently passed Pregnant Workers Fairness Act. This is now the new statute that just came out this year that essentially is going to allow pregnant employees protections similar to what you would find under the Americans with Disabilities Act. So employers are now going to have to go through an interactive process, reasonable accommodations for pregnant employees to the extent they may need such accommodation. We have our next webinar on November 15th is actually going to cover that statute in more detail. So if you'd like more information about that, definitely tune into that free webinar as well. And number 3 is going to be the PUMP Act, similar to the Pregnant Workers Fairness Act. The PUMP Act passed this year provides protections for workers that may need to express breast milk or something along those lines. It allows them the breaks and opportunities to do so. The next expansion of protected classes concerns religion and religion accommodations. So the Supreme Court just over the summer expanded the undue hardship definition for religious accommodations. So traditionally, if an employer did not want to accommodate a religion accommodation request, they would only have to show a de minimis requirement of hardship, right? Very, very small, very easy to meet. We saw this over COVID, right? An employee submitted a religious accommodation request and not get the COVID vaccine. Employers are arguing, well, there's a heightened threat to our patients, to our employees, that if they're not vaccinated, they may pass, COVID on to us, right? Increases that potential. And so they would say that increased threat met that de minimis standard. The Supreme Court's come out, not actually relating to COVID when they issued this decision. The facts of the case had nothing to do with COVID, but they've now changed that standard to being a substantial increased cost. We don't quite know what that means yet, other than the basic terms, as this has not been litigated in courts yet. But an employer is going to need to show some sort of, again, substantial increased cost if they were to grant that reasonable accommodation for religion. Finally, I do want to touch on briefly the application of the Americans with Disabilities Act. We are starting to see employers slip in their requirements to undergo an interactive process when an employee comes to them and says, hey, I have this medical condition, is preventing me from performing the essential functions of my job, or preventing me from coming in on time, or I may need to leave early, or I may need to take breaks throughout the day. Employers have kind of really 2 duties here. And the first is to, 1, determine whether or not that employee has a disability under the act that requires accommodation. And number 2, to the extent they do, going through that interactive process of determining what that reasonable accommodation may be, and working with the employee to do so. We're now seeing more cases of employers, just simply denying, hey, no, I can't let you leave early for those medical appointments, once a month or something like that. That's just not something we're going to do, despite that employee have disability that they need to go see the doctor for. So we're seeing a substantial increase in litigation. I think on here is, again, I have as a second bullet point, we've seen a 500% increase in ADA and religious discrimination cases just in the last 2 years. So definitely, if you have employees coming to you saying, hey, I have this medical condition, I need a change in my work requirements because of it, definitely be speaking with your attorney or other, trusted HR advisor to ensure that you're going through that interactive process accordingly, because the EEOC and here in Ohio, the OCRC are really starting to ding employers for not following that process. So again, employers needing to act, definitely be updating your policy. You need to implement policies for the Pregnant Workers Fairness Act, as well as the PUMP Act. Also, it's probably a good time while you're doing that, just to audit your ADA policy to ensure that, that process is really laid out as to how to go through the interactive process. While you're at it, you can also add sexual orientation, gender identity, and gender expression to your protected classes categories, such as in your handbook. Again, always a good time to do general training on discrimination and harassment. We advise a lot of our clients to do that at least once every 1 to 2 years with your HR, depending on turnover, to ensure that managers and HR are aware of the requirements. And then again, for really high level HR and managers, also training on that interactive process under the ADA, and now the Pregnant Workers Fairness Act, because they're very similar processes. So, and then also, if you have religious accommodation forms that you implemented during COVID, you may want to take another look at those as a result of the Supreme Court's decision. Maybe have them audited by an attorney or again, an HR advisor, just to ensure those are compliant with the recent legal changes. All right, I think I did it. I did it in 30 minutes. So Sarah will be happy with me for that. But if there's any other remaining questions, I'm happy to stay on and answer those for you all. And if there's something you'd like to discuss, maybe offline, my contact information is on the screen now. So definitely reach out to me and we get something scheduled and discuss. Sarah, do we have any more questions?
We don't have any more at this time.
Great. Well, like I said, if anyone has any questions they'd like to discuss further, please reach out. Otherwise, I hope to see you all again at our next webinar, which I think is in 2 weeks, which we're going to be discussing marijuana in the workplace. Definitely a really hot issue here in Ohio right now, with issue 2 on the ballot. But to what extent employers need to require or allow employees to use medical marijuana, and to what extent they still might be able to discipline and fire or not hire based on such recreational use of marijuana. So that's in 2 weeks, and I think the week after that, on November 15th, is going to be the Pregnant Workers Fairness Act webinar. So definitely register for that one. Again, it's free. We're going to go over those requirements. And I think that's all I got. So thank you all again for attending today, and I hope to catch you again at the next one.